Hi, we are here to present the case that is Presidential Security Services of Australia Private Limited versus Brilley. The controversial topic of injuries sustained in the course of criminal activities has had another hearing in the New South Wales Court of Appeal, although the outcome was somewhat uncertain. In the early hours of 23rd of June 2003, Clinton Brilley and three others broke into the Earlwood Bradwell Park Sport Club with the intention of stealing cash. However, the unknown to Brilley and his accomplice, David Bingle, a security guard, was in the club. Shortly after they entered in the club, Bingley fired a magnum revolver and wounded Brilley. He then fired at the accomplice, who promptly fled. According to Brilley, Bingle was pointed the gun on Brilley's head and chest and pressed the trigger repeatedly, but the chamber was empty. Bingle attempted to reload the gun. While he was doing that, Brilley ran out of the club and jumped into the car. As the car drove away, Mr. Bingle fired at them and causing the rear window of the vehicle to shatter. Bingle was managing director and sole employee of the Presidential Security Services, and he was guarding the premises in the course of his employment. Brilley sued for the damages for personal injuries for Presidential. Only he relied on both negligence and assault or battery on the part of defendant, though its servants, agents, and subcontractors. In the district court, the claim is negligence was dismissed, but the claim based on assault, battery, and uphill Brilley was awarded damages totally with some $185,000, including both aggregated damage and exemplary damages. Presidential appealed to the Court of Appeal, arguing that the trial judge failed properly to consider and apply the provision of Part 7 of the Civil Liability of 2002. The Part 7 of Act contained three relevant provisions rely on the Presidential Section 52, 53, and 54. Provides that damages are not be rewarded where the plaintiff was injured at the time of committing an offence. Presidential initially argued that the exemption in the 54 could be not applied because as it was a company, it could not be liable to offence a assault by Brilley. That argument, however, was rejected after a thorough analysis of relevant legislations. It also challenged the trial judge's faculty finding, and in that regard had more success. Justice Ip found that trial judge's conclusion contained several inconsistencies which affected the unlimited outcomes. More importantly, the trial judge had engaged with the defense of Presidential. In the particular, trial judge had not properly considered the defense of self-defense. In the result, the appeal was not allowed, but the matter was remitted at the District Court of Rehearing. Brilley argued that asked for the compensation he demanded that the injury he got was not at a time of crime. The security officer fired at him because when he was trying to run away, it was not a case of self-defense, it was a kind of punishment. But on the other hand, Brilley was guilty for committing this crime. He was simply cannot argue, but that he was trying to escape, so security officer should simply let him go. He is not harming anyone, but he should consider that the fact he committed the crime, then he was trying to escape. He cannot accept a normal civilian treatment. The security he is a criminal. If not being imposed, he will continue to harm others, commit more crimes. Security training includes how to deal with such situations, and they should be prepared and trained to deal with these sort of situations. But security officer's action was kind of amateur, and he should not be authorized to carry a gun, any sort of arms which could be dangerous for anyone. But the company at all form of above scenarios, and the obligation we can say security officer was doing was at fault because he was not supposed to fire at Brilley. It can cause even death or injuries someone, and he will have to suffer for a lifetime. The right action could possibly be reporting to police or trying to chase him or catch him, then hand over to police.